From the very first moment, the tension in this courtroom is undeniable. A defendant faces a mountain of charges, each carrying life-altering consequences. As the judge presses for answers, one thing becomes crystal clear: this is no ordinary hearing. The stakes include decades behind bars, allegations of violence, and a chance at redemption that's slipping away fast. Today, we witness not just legal arguments, but a battle of self-control, credibility, and truth.
If you want to go to trial and not accept a plea agreement, then listen to your attorney and do what he's telling you to do.
Okay, so basically it's completely off the table right now, the plea?
Yeah.
The judge wastes no time establishing order. She reminds the defendant that courtroom decisions hinge not on excuses, but on accountability. Notice how she halts interruptions, firmly shutting down rambling defenses. This moment sets the tone. The court is not here for distractions, but for justice. How often do you think jurors are swayed by a defendant's attitude, not just the charges?
Stop talking. This is cause numbers 24 DCCR 1500, 24 DCCR 1614, 1615, 25 DCCR 0436, and you're Traylon Hill. And Mr. Hill's charged, go through this, in cause number, the first one, 1500, with obstruction or retaliation. Do not do that again. Who's in here for him? All right. Ma'am, can you move over to that back corner so that he cannot see you and be distracted? Thank you for being here. Mr. Hill, you just don't know how to...
Frustration rises as the judge calls out the defendant's disruptive behavior. Despite apologies, the record shows repeated misconduct, even inside jail. Instead of remorse, we hear justification, bullying claims, nicknames, and excuses. Yet in the eyes of the law, actions speak louder. When defendants blame everyone else, how credible can their defense truly be?
Behave, do you? Saying you're sorry doesn't matter. This is nonsense. Since we were here last time, I don't even know how many more pages of the nonsense that you've been doing in our jail.
It's gaslighting. It's solicitation.
Okay.
And I've been trying my best to stay out the way. I've been getting bullied over the microphone. I have inmates, they're encouraging the inmates to harass me, call me punk, alpha, profit, plenty of things. Gangster player, mad.
As the defendant shifts to personal hardships, family business, an nagging father, and responsibilities, the judge listens but remains unmoved. These claims may evoke sympathy, but courtroom justice does not hinge on background stories. Every juror must ask, does hardship excuse criminal acts, or does accountability transcend circumstance?
Yeah.
Mortar, man, I'm just trying my best to stay out the way.
Okay.
I got a job, I got a home, an actual home. I don't stay in apartments or anything like that. My mama actually owns rent houses. And you know what I'm saying? I'm actually trying to take care of the family business. And my dad's 76 years old.
Yeah.
My best to stay out the way.
Well, it doesn't look like you are.
Yeah, it's tough in that facility. It's a war zone.
So one of the time you're running back and forth, playing like a little kid in the day room. Who made you do that? Are you allowed to do that in the jail?
In the rec room, yes.
Okay, so are you allowed to do it in the other room?
I have a one-man cell in the facility.
Are you allowed to do that?
Yes, ma'am.
You are?
I'm running freely throughout the facility or anything. But I do work out a lot.
So who made you dash the floor with water?
Everyone in that facility has a water
Who
bottle.
made you?
The conversation turns to bizarre behavior in custody, dashing floors with water and causing disruption. At this point, the judge dismantles his excuses with rapid-fire yes or no questions. Under pressure, the defendant admits, no one made him do it. It was his choice. A powerful reminder, in court, denial crumbles when facts corner the truth.
Dash the floor with water.
I'm not the only one.
Listen to my question.
No one did.
No, but you did it on your own,
Yeah,
right?
it
Nobody's stop talking when I'm talking. I'm going to ask you some yes or no questions. So nobody's making you do those things, right? Nobody bullied you into dashing water, right? Yes or no?
Yes, ma'am.
Okay, hold on a second. What about why?
Then comes a troubling revelation, persistent comments to female officers. Despite clear warnings, the defendant dismisses the misconduct as being a lover boy. The judge immediately exposes the flaw. Failure to follow even simple rules jeopardizes his entire case. How much damage does casual disrespect do when a jury is asked to weigh credibility?
Do you continue to make comments to the female officers out there? Why do you think that's okay after you've been told not to do that?
Sitting in the field all day long, man. When I see them women, I get to flirting. I'm a little boy. I admit that.
Because you're a lover boy?
Yes, ma'am.
So you understand that part of all of this trouble and you not being able to get your cases worked out is because you can't follow that rule.
Yeah, I hate that.
Did somebody bully you into being that way to those officers?
In a manner, you know what I'm saying? When
Oh, yeah?
I'm dealing with these stressful inmates, you know what I'm saying? I love to be around my
Okay.
mama boy.
Judge, based on his Sunday night activity, I'm pretty sure there'll be a new case coming.
Yeah.
I've got a call into the investigator for the sheriff's department to find out
Okay.
when they'll bring that over. But I would ask them to go ahead and set these in for trial.
And we've already talked before about the fact that everything that's happening, a jury is going to know about all that. You understand that? Okay. And do you think that's going to help you or hurt you when a jury hears how you're behaving in the jail?
When it comes down to video footage and how I explain it, I think my efforts will be pretty good.
You think so?
Yes, ma'am.
You think so. Let's go through real quick before we do this rejection. And cause number 2.
The charges roll out, one after another. Obstruction, aggravated assault with a deadly weapon, aggravated robbery, burglary of a habitation. Each offense carries staggering penalties, up to life in prison. The courtroom grows heavier with each word. Can a jury truly overlook behavior in custody when evaluating charges this serious?
24-1500, you're charged with obstruction or retaliation. Is that a third
That is the third, Your Honor.
third-degree felony, which means if you're found guilty, the range of punishment is between 2 years and up to 10 years. Do you understand? And cause number 24, DCCR 1614, you're charged with aggravated assault with a deadly weapon. And second-degree felony offense, which means the punishment range is between 2 years and up to 20 years in prison if you're found guilty. Do you understand that?
Yes, ma'am.
And cause number 24, DCCR 1615, you're charged with aggravated robbery, which is a first-degree felony, which means if you're found guilty, the range of punishment is a minimum 5 years up to life in prison. Do you understand? And then in 250436, you're charged with burglary of a habitation, which is a second-degree felony. The punishment range in that is between 2 years and up to 20 years if you're found guilty. Do you understand?
Correct.
I have here on the computer a plea bargain rejection that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty.
A critical crossroad emerges. The state offers a plea deal 10 years for robbery, dismissing all other charges. It's a lifeline, but the judge makes it clear, after today, no more deals. The decision is stark: take the offer or risk life in prison. This is where choices define destiny. Would you gamble with the rest of your life or accept the certainty of 10 years?
For a 10-year term in prison on a lesser offense of robbery,
Robbery and dismissal of the other charges.
you have every right to reject that.
It was an excellent deal, but
That's fine. I just want you to know that after today, I will accept no plea agreements. A jury is going to decide, because I don't know that I even agree with this. So today's the day. If you want to take it, fine. If not, you're going to trial. A jury will decide if you're guilty or not. And then if you are found guilty, that jury will determine what your punishment is. And is that what you want to do?
all these charges going to be on one trial?
They don't necessarily have to be, because you've got 3 different dates.
Your Honor, the robbery and aggravated assault are in the same offense day. I'd expect to try them together.
Okay. So what can happen is
The defendant declines. The judge warns multiple trials could follow, sentences may be stacked, and decades could accumulate. This is courtroom reality, where stubbornness can turn a single case into a lifetime of consequences. Justice is not a game of chance. Yet here, the dice have been thrown.
You will, sounds like the aggravated assault and the aggravated robbery will be tried together. It's important that you understand also, if you're found guilty on those, then the state can also try you later on one or both of the other cases. If you're found guilty on those, because the offense dates are different dates, there is the possibility that any sentence that a jury gives you could be stacked or run consecutively. Do you understand? Okay. All right, we'll get it set for trial. Go back with the bailiff.
A second case emerges, this time a sexual assault plea. The defense paints the defendant as remorseful, with family support and a long gap since his last conviction. But the state strikes back: age differences, intoxication, and exploitation of bad choices. Both sides clash over responsibility. When responsibility is blurred by excuses, how should justice respond?
Good morning. Are you Derek Ardwan? And Mr. Ardwan was previously in court in cause number 25, DCCR 0350, entered a plea of guilty to the second-degree felony offense of sexual assault. The agreement was for a cap of 6 years in the institutional division of the Texas Department of Corrections. I have received the pre-sentence report. Has everyone had an opportunity to review that?
We have, Judge.
Any additions or corrections?
None from defense, other than something I'll clear up on argument.
Okay.
I have nothing.
Go ahead.
Well, Judge, when you read the PSI, it's several times Mr. Ardwan does take responsibility for what happened, for his actions. I know there was some talk from the PSI writer that seems that he was minimizing or still deflecting some of his responsibility in what happened. I did speak with Mr. Ardwan about that. He said that toward the end of their interview, he understood more what the PSI was saying, because there was 2 people from probation there at the time.
Yes, sir.
And so as the second person started to intervene, he understood. And so he totally takes responsibility for what happens. He understands the situation. He shouldn't have been in, him or the complainant, during that situation. He was going through a situation with his girlfriend. It wasn't his wife. It's not his actual stepdaughter. His girlfriend, and started getting more attention from the stepdaughter than he should have, and he went along with it. Shouldn't have, but he did. It wasn't a situation with someone underage or anything like that. She was definitely of consenting age. Being in a relationship with him, they started hanging out a lot more, almost in a dating scenario, if you will. And then it escalated to the point where they worked together that evening. Nothing of force, anything was happening. To my client understanding at the time, he thought everything was consensual that was going on. It wasn't until later, until this investigation, that he realized her stance or argument of her being intoxicated to the point where she couldn't give consent, legal consent or anything during the activity. I would like to point out with him, when you look at his criminal history, he has not had any type of criminal history since 2001. So since he was in trouble that one time, or that last time there, he has done everything he can to try to keep his life on track and not revert back to any of the old activities he had when he was younger. My understanding is, he does have a lot of family support. I've been in touch with several members of the family that have reached out to me. My understanding is that the mother of the complainant is still very supportive of it. And to the point where, even though he moved out and was away from her and everything like that, she still wanted to pursue their relationship and work on their issues. He is asking that the court consider community supervision in this situation. I think it definitely could be appropriate here in a situation where he's a registered sex offender at this point, so he will be able to get any of the attention or that he needs through any sex offender classes or through their registration, as well as I think that there's several vehicles available through probation that could help with any other additional issues that he does have. So at this point, Judge, we are asking the court consider deferred adjudication in the situation with Mr. Hardwine.
Thank you. Ms. Monfino?
Judge, although the PSI reflects that they were unable to contact the complainant, the notes in the case reflect that our office has, and she seemed cooperative and wanting to go forward with the prosecution based upon that, based upon the nature of the offense, the circumstances that even Mr. Lewis himself has described with respect to, she may be considered a legal adult, but the difference in their age is quite substantial. Obviously, he took advantage of the fact that she was making bad choices with respect to drug and alcohol use and got herself in this position. So on her behalf, Judge, the state would argue for the 6 years under the cap of deferred enforced discretion force.
Thank you.
And in fact, just may confirm in case the question arises, he has already completed the sex offender registration paperwork.
Oh, yes.
Yeah,
Yes,
I think we did that at the plea. Mhm.
Just check.
Thank you. So I guess my thought is on this, I don't disagree with Ms. Moss.
Finally, the judge delivers her decision. Instead of prison, the defendant faces 10 years of probation, a $1,000 fine, and mandatory completion of a sex offender program. But it comes with a warning: any violation and the full weight of 20 years looms. This verdict is not mercy, it's a test. Will the defendant rise to the challenge or fall back into old patterns?
Fino, that prison time isn't necessarily warranted. It sounds like you got yourself in a predicament that you're way old enough and grown up to know better. She wasn't a minor. There was a lot of things that looked like they were consensual up until a certain point where y'all probably, it sounds like we're both so intoxicated, you clearly didn't know what was going on. 6 years, you're out in a few years. There's no treatment. There's none of that I think would be helpful. And so I think, to me, the better and maybe even more difficult thing for you is a probation, because this type of probation is not going to be easy. So what I'm going to do is find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to defer all proceedings and place you on probation for 10 years. There's two things that are, well, let me finish and then I'll go through some other stuff. I'm going to order a $1,000 fine. I'm going to order that you follow all of the rules and conditions of probation, and that includes entering and successfully completing a licensed sex offender program. To successfully complete the program, you also have to admit what you did. So it's very important that you get in that program, you take responsibility for your part in what happened and how you got to this position so that you're never in this position again. You're obviously already signed the paperwork and understand that you will be required to register as a sex offender. If you don't register timely, then that's a violation of your probation plus another felony offense. And so you've got to take care of everything you're supposed to while you're on this probation. So the good thing about that is it's a deferred probation and there's not a conviction. The good thing for me and potentially Ms. Malfino later is that by doing this deferred probation, that cap of 6 years is off the table. Okay, that's over today. I didn't give you prison time, so that's gone. If you violate this probation, I then have the entire punishment range, which is 2 to 20 years in prison if you violate. So there's no coming back and saying, I want the 6 years or I violated and I've got the whole range. I'll look back at this and I'm sure I'll be reminded at what their argument was, and it's not likely to be 6 or less. You understand? So I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal Now, obviously, a part of this probation is that you have absolutely no contact and no communication with the victim. And so if there's some relationship that you're still having with her mother, it cannot be at a place where she is. You cannot go to wherever she's working. If you go into a restaurant and then she comes in after you, you're the one who has to leave. It's up to you to remain away and not have any contact or communication. You understand?
Yes, sir.
All right.
Two defendants, two very different paths. One rejects a plea and risks life behind bars. The other avoids prison but faces a decade of intense probation. These cases remind us that in the courtroom, choices carry consequences, sometimes harsher than the crimes themselves. Justice is not just about laws, it's about accountability, responsibility, and the ability to change.